Any mention?
May I please, Your Lordship, I beg to mention item 1, Your Lordship.
Number 1
Yes, Your Lordship, for hearing.
and 2.
1 and 2, Lordship. Yes.
Links, no? Where's Mr. Siddiqui is not there?
No, Your Lordship, he's indisposed, Your Lordship.
Okay, after 2 weeks is.
That should be right, Your Lordship.
Must process. Yes.
Your Lordship, like to come after 6 weeks, but because time and again they are asking the judgment.
Okay, 6 weeks.
After 6 weeks.
Otherwise, in other case, the judgment has already been rendered regarding challenge to that Mahalaw regulation. Just along the same lines, will go. You're challenging something. Yes. Yes. Next.
Item number 3.
I mean 3 as well. We are seeking accommodation.
Who's seeking, the union or you?
I'm seeking on behalf of Mr.
After?
Chanda. It's a 3 weeks, Lordship, because 3 weeks.
Okay.
3 weeks.
Next.
There are only 3 matters.
Okay. I hope you all enjoyed your holidays.
Yes.
Yes.
Congrats.
What's the book? Sorry, no.
Any mention? Item number 1.
Say together, no? I think also.
Inform people to be fine. Are you ready for the hearing today?
Lordship, we need another time. Little more time. I have filed my
For the
reply.
money, you've already got 50%.
Only 50% we have received.
Yes. Dr. Mojika, where's the informal paperwork? Are the direction last time that
Direction. They filed their affidavit, but otherwise all the papers are available in non-record. We have annexed all the papers. But that was a practice.
Even I have submitted all the papers, whichever is.
all the materials are.
Lordship.
Yes. Yes, then what to do? When do you want it?
Lordship, somewhere
Others we have
end of October, 31st October. Not Monday, because Monday traffic is very high.
Yes.
I'm here any day.
Yes.
31st is a Friday. Friday may not.
Friday.
May not. Yes.
29th?
30th.
29th?
29. Okay. Yes. The request of Miss Embora.
Lordship.
Yes. Because we might have new roster.
Yes, ma'am.
So we just posted after. Now it's after 3 weeks.
After 3
Correct date. This matter of 3 weeks.
Lordship, if it is
Date-
specifically
date-
mentioned to be in the
roster
top
might
of
change.
list.
So this bench might not be there anymore.
Okay.
Right. So for the matter, the arbitration appeal. Yes.
Much obliged, Lordship.
Obliged.
Any mention?
May I please, Your Lordship? Lordship, I beg to make a mention for item number 13, Your Lordship.
Number
13.
13.
Yes, Your Lordship.
Yes.
Your Lordship, I pray for 3 weeks' time because we're still waiting for the parawise comments, Your Lordship.
You're for the respondent here.
Yes, Your Lordship. We're waiting for the
Where's
parawise
the petitioner?
comments, Your Lordship. I'll inform them, Your Lordship.
No. You inform them beforehand. Otherwise,
It's in the order column. Order columns. Order column.
order column. Why are you mentioning order column?
My apologies, Your Lordship.
That is inexcusable. Yes.
May it please Your Lordship. Your Lordship, I beg to mention item number 23, Your Lordship. The conducting counsel is not available today. Miss N.G. Shilla, Your Lordship.
Who's going to counsel?
Miss N.G. Shilla, Your
You'll
Lordship.
inform the other side.
I'll inform them, Your Lordship.
You'll inform or you will inform?
I will inform. I have
No,
not
then
met.
we will let them come, please.
Your
Yes.
Lordship.
Wait, please, Your Lordship. This is a joint prayer for adjournment for item number 25, Lordship.
BSF.
Yes, Lordship.
After
2 weeks.
okay, 2 weeks. Yes.
Highly obliged.
Yes.
May I please, Your Lordship? I beg to mention item number 24, Your Lordship.
You inform the other side.
Yes, Your Lordship.
You sure?
Yes, Your Lordship.
2 weeks.
Yes, Your Lordship.
Yes. Okay. Yes.
May it please Your Lordship, I beg to mention item number 27. I pray for 2 weeks' time, Your Lordship.
No objection.
Yes.
Item number 1.
Lordship, in this case, the grievance of the petitioner that he was promoted to the post of the chief
Who's
account
taking
officer.
notice acceptable to the other side?
Other side,
You're saying for service benefits.
he's asking for the notional increments, which was not given to him on his promotion to the post of the chief engineers.
When was he promoted?
He was promoted on 10 March 2022. In para 12 April, the petitioner submitted a period over 3 years.
He's retired now.
No, he retired.
Okay, yes, heard Mr. M. F. mention. And the council should issue notice. Mr. M. Palar accepts on behalf of
Respondent number 1, Your Lordship.
number 1, notice to issue respondent number. Where's MS Coolney? 2, 3, and 4 within 2 days. List after 2 weeks. Yes.
Item number 2.
May I please?
Number 7.
Item number 2, Your Lordship.
Yes, you have not filed. Why?
Your Lordship, due to some technical default, we could not file it.
What technical defect?
Your Lordship, the counsel for the identifier counsel has not identified and they send it to us. So we have forwarded again. Yeah.
Yes. As paid for further 1 week's time without respondent number 7 to file affidavit. Just thereafter.
Item number 3.
Lordship, Mr. Number is still on next, Your Lordship.
Where's Mr. Day? What's it for today?
They are supposed to file the affidavit, Lordship.
You're supposed to file?
Affidavit, Lordship.
You're supposed to file?
Lordship. For the main,
Who's supposed to file?
the JCDC.
Where's JCDC? It's like delayed by 354 days. Yes, where's JCDC? Yes. MSJT Sangma is present on behalf of the petitioner. There's no appearance. Oh, she's here, yes. You would file objection to the condemnation application for this review?
Yes, my lord.
Was it admitted?
No, my lord. Only notice was issued, if I'm not mistaken.
Yes. It's not admitted yet. Have you filed objection, Mr. Pasanpir?
No, Your Lordship.
Then, what do you mean by Mr. Nomri is on legs?
Will be appearing, Your Lordship.
You were here last time also. What do you mean he's on legs? You know, for arguments today. Don't make this kind of submission that he's on legs. You haven't filed it. We'll admit the review.
It just takes some time, Your Lordship.
Where's the application for condemnation? We'll file in this case.
Yes, Lordship, we have already filed.
Where's it? I gotta miss case. I can miss case. Huh?
On 9 June, we have filed, Lordship.
It's already been condoned.
Lordship.
The delay. Then you don't know that also.
My lord, notice was issued, my lord. They were supposed to file an objection, my lord, on this.
No, in 5/8/2025.
Lordship, for miscase, they have said that they have no objection for the miscase.
For me, I have no objection, my lord. I don't know about them.
It's already been. Yes. So we'll post it for hearing.
My lord.
Yes, that's also with the council. Just a matter for hearing of the 3 weeks. Yes.
Item number 4.
Please, Your Lordship, we will file the affidavit in the course of the day.
Yeah, for whom?
For the respondent.
Sole respondent.
Sole respondent.
Is your name?
Emma Thorpe.
MS Emotho, learned counsel for the sole respondent, submits that after we find the course of the day. This week, yes.
5.
Lordship, I'm paying 2 weeks time to file marriage on the here, Lordship.
You already given 2 weeks time.
Yes, Lordship, this is second time, Lordship.
Just for 2 weeks time. Allowed for rejoinder. As paid for the 2 weeks of rejoinder.
Obliged, Lordship.
6. Item number 6.
This matter can be posted for hearing, my lord. They have already filed their rejoinder.
As the parties submit pleading is complete, it's a matter for hearing its own.
Obliged, Lordship.
Item number 7.
May I please, Your Lordship. I'm for the private respondent number 4, Your Lordship. I'm praying for some time, Your Lordship.
We already granted further 2 weeks time as prayed. Allowed respondent number 4 reply affidavit. Rejoinder, you've already filed.
Lordship.
Let her come after 2 weeks. Yeah. Just
Item number 8.
Obliged,
Lordship.
Lordship,
yes.
this is a pension matter, Lordship. Here, on the last day, the state respondents, they have admitted that they do not have any objection with regard to the release of the pension. Now the accountant general, they wanted to file the affidavit, Lordship.
I'm filing, Your Lordship. I have received instructions.
Why no one appeared last date?
Lordship, there's some.
Is the affidavit ready? Pension matters, we don't want to.
Because the government do not have any objection, Lordship.
No, we don't want to,
1 week's time, Lordship.
hold them. Yes, MS Pasa and Constable 6. So, praise if allowed 1 week time to file affidavit stuff. Prayers allowed. Next date, we dispose it off.
Item number 9.
Lordship, in this I'm appearing for respondents 4 to 8, Your Lordship. I may be allowed some more time to file my affidavit.
What's the matter about?
Lordship, this
Payment
matter
of
whether
pension.
No, Your Lordship, where the retirement benefits of the staff of MIDC are stopped, Your Lordship, because they don't get pension. They get retirement benefits, lump sum amount.
That has been stopped also.
That has been stopped, Your Lordship.
May it please your lordship. Lordship, in fact, in this matter 9 and 10, I filed one misapplication, your lordship.
Where's the misapplication?
Your Lordship, in that miscase, I've prayed to file an objection.
Let's see. What is it about, Mr. Shulai?
Striking them as a party in there.
The Committee on Public Undertakings.
Lordship, yes.
It's a MIDC or is it?
I am for the MIDC, Your Lordship. The government is also there.
Your Lordship, on the basis of the
petition here now.
Where is that? You don't have?
Huh? Give
me that miscase.
Why you made them as a party 12?
Your Lordship, on the basis of the complaints made by the AG, Accountant General Audit and the Committee on Public Undertaking, this decision was taken by the MIDC. For that reason, we have made them a party.
Yeah, the way you want to strike them out, Mr. Shulai?
Lordship, because what happened, your lordship, if lordship goes to the relief claim in the petition, there is no relief claim against the respondent number 12.
They might not claim relief, but he might be a formal party within the
Your Lordship,
state.
page 101 is the
I'm neither a necessary party, your lordship.
101.
101 is the impugned order, Your Lordship.
Keep the first case.
Oh, yeah. Yes, Mr. Shulai.
Lordship,
Why
because
did we struck out? Because it's on your decision.
Lordship, because lordship,
what have you said in this case?
Lordship, kindly come.
Lordship, in the miscase, they are stating that it's just a committee which is being formed by the Speaker from time to time.
Lordship, kindly have para 3 of that.
Miscase?
Lordship, yes.
No, even then, if the committee might be not by the same people, but the decisions will be there on record. So we'll reject your Mr. application.
Lordship, because this is a committee, your lordship, set up by the speaker, by the honorable speaker, your lordship. So
it's not a juristic personality.
If lordship goes by article 212, your lordship, that means lordship, the committee is immune from
212
lordship,
of
yes.
the rules executive business.
No, lordship of the constitution, your lordship.
The articles are
Lordship,
not
today I'm a little handicapped. If lordship, I take up this matter tomorrow, your lordship.
You want to file objection?
Your Lordship will file.
Yes,
I'm
sir.
little
First one,
handicapped,
Miss Case 197 to 25 in so. That is an application for striking off respondent number 12. That is a committee on public undertakings in the Meghalaya Assembly in the connected petition stop. MSBF Paranlang, please fill out to file a small objection to the same. Prayers allowed. List after 2 weeks. In the main case,
Your Lordship, I pray for 2 weeks time to
you're
file my
appearing for who?
affidavit. Respondents 4 to 8, Your Lordship.
And in the main case, MS Tiangi B Leonard EAG for respondents number.
Here I am as a senior advocate, Your Lordship, not
Number
4 to 8, Your
4 to
Lordship.
8. What about 9? MSE Pasab. You want to file affidavit also 9 to 11? And
1, 2, 3, 1.
And second for 1, 2, 3. Pray for Lord for the 2 weeks time of the affidavit.
Lordship.
2 weeks.
Next matter also same, your lordship.
9 and 10.
Item 11.
Yes, my lord.
I'm still awaiting instructions, Your Lordship.
For what?
Regards to because the pension has been approved, Your Lordship.
Approved, no? Pension is approved.
Since it's been approved.
It's approved, my lord.
Still waiting your instructions, Your Lordship. From the petitioner, Your Lordship.
Where the petitioner stay?
I'm not in direct contact with the petitioner.
Then we'll close it.
Just let me some time for instructions, Your Lordship.
You've had when it came on 16/9. Now we're sitting in. It's the 5th of October. We'll close it then. This is 24th April 2025. This order.
Last opportunity, Your Lordship. I'll just seek proper instructions whether she has received or not.
No, my lord, she has not received. It's been approved. She has to. There are other formalities that she has to complete.
Yes, we will dispose it off on the last date. MSOI Bank, London GA, had produced a communication dated 24/4/2025, showing that a family pension for the writ petitioner had since been approved and that nothing remains for consideration. Stop. This court, on the prayer of Mr. F. Pasantio, had adjourned the matter to allow him to receive instructions. Stop. Today, however, he submits that he is not in direct contact with the writ petitioner and as such could not obtain the required instructions. Stop. Next paragraph. Be that as it may, in view of the approval order dated 24th April 2025, is on record, and also the communication dated 15 May 2025 addressed to the Accountant General E.M.E. Meghalaya with regard to the approval of the grant of family pension writ petitioner. This court deems it fit to close the matter at this stage by directing that the entire process should be completed at the earliest, preferably within a period of
3 months, Your Lordship.
2 months, and the family pension be released to the writ petitioner.
Yes, my lord.
Otherwise, you don't pass the direction, they'll take long time. Writ petition, for instance, is for that.
Highly obliged.
Item 12.
Yes.
Lordship, let the matter come up for hearing. In the meantime, I'll file my rejoinder, Lordship.
File your affidavit, my lord.
Oh, we are not filing, Your Lordship.
No affidavit.
We won't file, my lord.
We have filed, my lord.
Only 13528.
528. Yes.
Have you filed it? Your joint has been filed.
I'll be filing my rejoinder, Your Lordship, but in the meantime, let Lordship some more time for filing a rejoinder.
When?
Not 2 weeks, Your Lordship. Let the matter come up for hearing. In the meantime, I'll file my rejoinder, Your Lordship.
What about this miss case? What's this miss case 165?
It's for stay of the order, Your Lordship.
It's been stayed.
There's an interim order, Your Lordship.
But you wanted for final hearing?
Yes, Your Lordship. In the meantime, I'll file my rejoinder.
You okay with that?
Let it come up for hearing.
Mr. Author submits that please that the matter may be listed for hearing, and he will be permitted to file. And meanwhile, praise allowed. Just after 3 weeks, the journal will be filed in the meanwhile. So the affidavits filed by respondents number
528.
52 number 1, 2, 3 and
528, my lord. Oblige.
Item 13.
Yes. Where's the petitioner? Yes.
Maybe, please, Your Lordship, I could contact Mr. Khera.
No, it's all right.
But
No,
3 weeks' time needed.
Yes. No, he wrongly mentioned it.
My sincere apologies, Your Lordship.
3 weeks' time for
contact.
contact.
14.
Here, Your Lordship, we have received instructions. I just need 2 weeks' time to file my affidavit.
What about?
I haven't received the report, Your Lordship, from GPO. 2 weeks' time may be given.
Your name?
C. Rapsang.
C. Rapsang. There's no other Rapsang practicing with Mr. Kinching? No. Okay, so MSc Rapsang admits that she has not been able to obtain the status report of service of notice upon this 146. He prays funds allowed for the 2 weeks time for the same. And
I pray for 2 weeks time, Your Lordship. State respondent.
MS Young EB, then AG appearing for state respondent who also prays for some more time and affidavit from this after 2 weeks. For the order, yes. For affidavits, for the order.
Item 15.
May it please, Lordship. Lordship, this matter pertains to the dismissal of from service, Lordship, and
so the plea is
my
complete.
Lordship, no, Lordship, I kindly see this order dated 13/8, Lordship. My learned senior has already authorized this court that a similar matter is pending, Lordship.
Here, Dr. Mozika.
My lord, in fact, the other matter is listed today in court number 3.
Court number 3, Lordship.
What's the matter about?
Dismiss,
What is
Lordship.
the personal, BSA personal, my lord?
Court number 4, number 3.
Number 3, Lordship, because of the reshuffling of the rooster, Lordship.
No, it should.
It was earlier in court number 4, Lordship.
By order dated 13/8/2025, the court has directed that the matter be placed before the bench where similar matters pending. So, the same has this matter be wrongly received for the bench. This records be transmitted to the corporate bench.
Obliged, Lordship.
Item 16.
16 is.
Made this is to Lordship.
Yes.
Lordship, this matter will need some more time, Your Lordship.
Why?
Lordship, we are yet to file the affidavit, Your Lordship.
Non-declaration of result, Your Lordship.
This is a case relating to
OBC,
OBC, Your
candidates,
Lordship. We don't have ABC here, Your Lordship.
Then what's the problem filing
Lordship, that is, Lordship, we need some clarification on that.
Because yes,
On
this
Lordship.
OBC thing will come up again and again. And the prayer from this initialized also, a further 2 weeks time allowed for affidavit.
Obliged, Your Lordship.
17.
Wait, please, Your Lordship. Your Lordship, the state respondents are supposed to file the affidavit, Your Lordship.
Lordship, I'm praying for some more time, Your Lordship.
But today,
1 week, Your Lordship.
what's the matter about pension?
No, Your Lordship. The petitioners were ostracized, Your Lordship, from the village.
It's the same one from.
Yes, Your Lordship.
These matters, I think we'll have closed them.
Your Lordship, they are supposed to file the report, Your Lordship.
Lordship, the FIR has been registered, Your Lordship.
No, this is that song, correct?
Yes, Your Lordship.
You better will close these matters because they already been given enough protection, I think. When can you file affidavit?
1 week, Your Lordship.
Hussein Pala pays for allowed for 1 week's time for affidavit. This also.
Highly obliged.
Item 18.
So Goswami, after the orders, yes, Mr. Advocate General, we just have it at the end.
Yes,
You ready
yes.
with the matter?
Yes, yes.
Your Lordship, there are two things. My friend has moved the application to withdraw the application.
Inconsequential, they file a fresh one, yeah?
That's it.
A fresh one. We have filed a fresh one. And
Yes.
I have also filed, my Lord, application to amend the repetition challenging the order also, my Lord.
Is it on record?
No. It has been filed in the morning. And we have
We file in the morning.
No, that's okay. We'll address that, Lordship, but let it be taken on. Let the matter be heard because the prayer for vacating is quite separate to what they have filed.
Yes, we take up the miss case.
Yes.
If the miss case, if we can settle the issues in the miss application, then the whole matter can be closed.
Yes, very well. Very well.
But after some time, end of the boy.
Very well, Lorships.
19.
Supposed to file the affidavit, Lordship.
We are getting some more time in item 19. And I think 1 week time in item 19.
What is the matter about?
This is regarding the central pool seats, Lordship, for MBBS, Lordship.
For which? For?
My lord, the petitioner
Yes.
applied for state quota, my lord.
Central pool
without
quota,
having any-
not state quota.
Oh, you're not eligible.
Let him file the affidavit, lordship.
Yes.
Let it come after a week, lordship.
Further 2 weeks as prayer allowed.
A week's time, lordship, because week's time, lordship.
See, tentative view, I think you're not eligible.
Lordship, even the ministry is here, your lordship. Because these seats are allocated from the ministry, lordship.
Is the petition eligible?
No, my lord, she does not have any documents.
Let the state come with instructions, or the ministry. Let the ministry. Let the ministry come with instruction after 1 week.
At least after 1 week for affidavit.
Second call 18.
Come. Put order. Yes. Where's your? Is you seeing your application for?
We have filed that because of that nomenclature, corporation thing, if Lordship will remember. If Lordship.
That is yes.
Yes. Kindly, if Lordship will take the last order. Written submission. Written submissions. Copies, enough.
Okay, this Miss case you seek to withdraw 247. Take down first. Miss case we just clear out the Miss case number 260/2025, WC number 33/2025.
Copies though.
There is an application and seeking withdrawal of the Miss case number WC number 247/2025 filed by the respondent.
Companies Act, Subsidiary of Companies Act.
The reason stated therein, the application for withdrawal is allowed. Yes, in this case disposed of, yes. And then in that this case number, that is number 247. Then in the next case, this allowed and 247, next order, Miss case number 247 for the reasons stated in the order dated so and so passed in this case number 260. This application stands closed on withdrawal. You had sought liberty?
Yes, Lordship, we have sought liberty.
With liberty to file a fresh application. Yes. Now you come to, where's the new Miss case?
Yes, 261, number? I think so.
261.
260 or 261.
Yes.
Now, before I proceed, Lordship, just for the convenience of the court, we have just formulated the issues for. Master, can you just hand this? Now, Lordships will kindly appreciate that the writ petition essentially was filed saying that the NCL. This is not what.
No, it's not from here. It's from Mr. Archival. I think there's some disturbance from your end.
Yes,
is there a lot of traffic outside your window?
Lordships. So, Lordship will appreciate that the writ petition was filed primarily on the premise that NCLT has no jurisdiction to proceed against a sovereign entity, which the.
I think that is a basic issue.
Yes. Now, please first and let us first see the insolvency code.
IBC.
If Lordship will have the insolvency code and the Companies Act. Let us first understand who is this company. Because before that, may I first read my first written submission for your Lordship's consideration. The writ petition deserves to be dismissed for suppression of material facts. Nowhere in the petition have the petitioners disclosed that it is a government company registered under the Companies Act 2013. The petitioner is registered as a state government company in the Registrar of Companies Shillong with registration number so and so. This very fundamental and critical fact ought to have been disclosed in the writ petition. On the contrary, the petitioner has made a specific averment at ground C, page 9 of the petition, that it is not a corporate entity. This misleading averment is good enough a reason to dismiss the writ petition with exemplary cost. Essentially, nowhere they have stated that they are a government company registered under the Companies Act. Now, Lordship will kindly come to the Insolvency Code, Section 3(7). subsection 7. What does the insolvency code subsume?
Corporate person, yes.
Corporate person. May I just read it?
Yes.
Corporate person means a company as defined in clause 20 of section 2 of the Companies Act 2013, a limited liability partnership as defined in clause N of subsection 1 of subsection 2 of the Limited Liability Partnership Act 2008, or any other person incorporated with limited liability under any law for the time being in force, but shall not include any financial service provider. So the first is, a corporate person means a company as defined in clause 20 of section 2 of the Companies Act. Now please see 8. Corporate debtor means a corporate person who owes a debt to any person. Now please come to the Companies Act.
My Companies Act.
We have to see.
Proceed. Mr. Advocate General, are you ready with the matter today for hearing on the Mrs. application?
That was indication, Lordship.
No, we have made it very clear that they have to put in objections before the matter.
Yes, and Lordship had also said the endeavor should be made.
Yes.
So let us proceed, Lordships. Why is there?
No, of course, Mr. Swami, you proceed.
Yes, I am.
No, we're not going to put in absolutely.
Yes, Lordships. Now please come to Companies Act section 2, subsection 10.
Yes. Yeah, let him mark. Yes, of course.
I will note down his argument, but I have one submission to make, because what has happened, my lord, that the application which was filed for vacating the stay has been withdrawn by now. My friend's client has moved the application to withdraw that application, and fresh application has been filed today, and it is listed that fresh application is listed. I wanted 2 days time. Your lordship may have it on Friday. I will file the reply before that, and Friday my friend can argue and I can argue also physically. That I can do it. I have no issue, and everything is there.
Mr. Goswami, if inconvenience, you complete arguments today. Let him reply, and you can apply online, no problem.
Yes. There.
You complete whatever you have.
Because Lordship will also
see I think the parameters are quite clear. The only thing they have to, in fact, for you not to argue anything, it's for them to justify.
Exactly.
That's the only thing as to why they have sought, invocation of 226. That's all. And whether this court, will, exercise discretionary power to, to interfere with the order passed by the
because the question is this: they have not projected themselves to be a government company, which actually they are. That is what I am trying to say. So therefore, see the Companies Act.
Yes, I think so.
They have nowhere in the writ petition told that's a major suppression of fact.
All your assumptions.
Yes.
It's not that.
Please see.
But the thing is that coming to the brass tacks.
This is the brass tax.
They have to show why they've come on 226. That's all.
And whether they are a sovereign.
They have recourse to section 61.
61 of NCLT.
Yeah.
Now please come to section 2, subsection 20.
Because as all the general precedents now that constitutional courts, don't interfere in these matters.
Absolutely, Lordship. Now please see section 20. Company means.
1 second.
Section 2, subsection 20.
Yes.
May I read it, Lordships?
Yes.
Company means a company incorporated under this Act or under any previous company law. And they are one because they are registered under Corporate Act. Now please see section 2, subsection 45. It explains what's a government company, which is what the petitioner is.
That's up to MPCDL ka jo
45.
Yes.
Yes.
Government company means any company in which not less than 51% of the paid up share capital is held by the central government or by the state government or by the governments or partly by the central government and partly by one or more of the state governments, and includes a company which is subsidiary company of such government company. So now it is starkly clear that they are a government company, and IBC 3(7) that I pointed out subsumes a government company.
Okay.
That is my first submission, Lordships. Now, just to make my...
They're not, yes, they're not excluded until they're specially exempted. From,
yes.
Yes.
MPCDL wala do na, ROC wala. Please hold on for 1 minute.
Yes.
Please for a moment, Lordships. Now, Lordship will kindly come to my second submission.
Yes.
This is not a case where NCLT lacked inherent jurisdiction. This is what I told Lordships also earlier. On the contrary, the NCLT did have jurisdiction to adjudicate on the Section 9 application filed by the respondent herein, in as much as that the writ petitioner is a corporate debtor. That is what we saw, Lordships, in the IBC. This will be evident from a bare perusal of Section 3, 7, 8, Section 6, Section 8 and Section 9 of the IBC, read with Section 220 and 45 of the Companies Act. This, Lordship, I had just indicated to you. Why are you not being able to find out? Now, please come to my third submission, Lordship. Judge Balmur. The petitioner is a government company engaged in a business of distribution of electricity in the state of Meghalaya. It is neither a sovereign entity nor does it perform any sovereign functions as per the tests laid down by the Honorable Supreme Court in this regard. I'll place 3 judgments. Please, Lordship, kindly take up Balmer Lorry for the first. Balmer Lorry, dijiye.
Citation.
I'll 2013, 8 SCC, page 345. Kindly have a look at this, Lordships. Next, nikale agriculture wala. Or फिर Chief Conservator of Forest.
Yes, which paragraphs, Mr.
Yes, Lordship. I will take Lordship straight to para 18 to 20, Balmer Lorry. Because this is a leading judgment on what is sovereign functions. Please come to para 18 to 20. At page 357 of the judgment.
Yes.
May I read it, Lordships?
Yes.
Often there is confusion when the concept of sovereign function is extended to include all welfare activities. However, the court must be very conscious whilst taking a decision as regards the said issue and must take into consideration the nature of the body's powers and the manner in which they are exercised. What functions have to be approved to be sovereign are the defense of the country, please mark it, the raising of the armed forces, making peace or waging war, foreign affairs, the power to acquire and retain territory, etc., and the same are not amenable to jurisdiction of ordinary civil courts. Then Lordship will come straight to para 20 because para 19 they deal with industry. Para 20 is very, very important. Every government function need not be sovereign. State activities are multifarious. Therefore, a scheme or a project that is like us, this is a Saubhagya scheme that we are working on. Therefore, a scheme or a project sponsoring trading activities as well as among the states may be well amongst the state's essential functions which contribute towards its welfare activities aimed at the benefit of its subjects, and such activities can also be undertaken by private person, corporates and companies. Thus, considering the wide ramifications, sovereign functions should be restricted to those functions which are primarily inalienable and which can be performed by the state alone. Such functions may include legislative functions, the administration of law, eminent domain, maintenance of law and order, internal, external security, grant of pardon, etc. Therefore, mere dealing in the subject by the state or the monopoly of the state in a particular field would not render an enterprise sovereign in nature. That is the test the court has laid. Because now the petitioner is saying that we are having a monopoly on this distribution. The court says no. The next judgment that I wish to place on this is, Lordships. Oh, before I go to the next judgment, just a document that Meghalaya Power Distribution Corporation is registered under the ROC. Lordship, just see this. This is from the ROC. We have taken out from the ROC.
Yes.
If Lordship will see that.
Yes.
Third page, first page of it. Company category, company limited by shares, company subsidiary, state government company. And second page, if Lordship will say, Meghalaya Power Distribution Corporation Limited is a private limited company governed by the Companies Act as a company limited by shares. So it's very clear that they are a government company. Now Lordship will kindly have a look at the other judgment that I was placing is agricultural produce. Lordship, this is 2008, 8 SCC, page 61. Kindly come to para 20 and 21 of this judgment.
Yes.
May I place para, Lordship is a para 20?
Yes.
In relation to what are sovereign and what are non-sovereign functions, this court in Chief Conservator 4S versus Jagannath Maruti Kondare held, we may not go by the labels, let us reach the hub. And the same is that the dichotomy of sovereign and non-sovereign functions does not really exist. It would all depend on the nature of the power and the manner of its exercise, as observed in para 23 of Nagendra Rao case. As per the decision in this case, one of the tests to determine whether the executive action is sovereign in nature is to find out whether the state is answerable for such action in courts of law. It was stated by Justice Sahai that acts like defense of the country, raising armed forces and maintaining it, making peace or war, foreign affairs, power to acquire and retain territory are functions which are indicative of external sovereignty and political in nature. They are therefore not amenable to the jurisdiction of ordinary civil courts, inasmuch as the state is immune from being sued in such matters. But then, according to this decision, the immunity ends there. It was then observed that in a welfare state, functions of the state are not only the defense of the country or administration of justice or maintaining law and order, but extends to regulating and controlling the activities of people in almost every sphere: educational, commercial, social, economic, political, and even martial. Because of this, the demarcating line between sovereign and non-sovereign powers have largely disappeared. The aforesaid shows that if we are to extend the concept of sovereign functions to all welfare activities as contended on behalf of the appellants, the ratio in Bangalore water supply case would get eroded and substantially. We would demur to do so on the fact that was stated in the aforesaid case, according to which, except the strictly understood sovereign functions, welfare activities of the state would come within the purview of the definition of industry. And not only this, even within the wider circle of sovereign functions, there may be an inner circle encompassing some units which could be considered as industry if substantially severable. In other words, it all depends on the nature of the power and the manner of its exercise. What is approved to be sovereign is defense of the country, raising armed forces, making peace or war, foreign affairs, power to acquire and retain territory. These are not amenable to the jurisdiction of ordinary civil courts. The other functions of the state, including welfare activity of state, could not be construed as sovereign exercise of power. Hence, every governmental function need not be sovereign. State activities are multifarious. From the primal sovereign power, which are exclusively inalienable, could be exercised by the sovereign alone, which is not subject to challenge in any civil court, to all welfare activities which could be undertaken by any private person. So it reiterates the principle. And the third is, Lordships, I will just give you the citation, and it is again reiterating, it's a 3-judge bench. It is 1996 2 SCC 293, Chief Conservator. I am just handing over, I am not placing the judgment because it basically reiterates the same principle.
Citation?
I am telling, Lordships, this is 1996 2 SCC 293. And I will be relying on para 11 to 17, but it is reiterating the same. I am handing over a copy of the petition.
Yes.
Now let us come to my, so that concludes my third submission.
Sovereign function.
That what they are doing is definitely not sovereign. Now I am coming to my fourth submission, Lordships. My written submission I handed over. Yeah. A perusal of para 8.6 to 8.9 of the judgment dated 4/9/2025 will clearly reveal that the NCLT has elaborately dealt with the issue pertaining to its jurisdiction and has correctly negated the case advanced by the writ petitioner. Under these circumstances, the instant writ petition is an abuse of the process of law. And if Lordship will kindly have a look at those paragraphs, or it has elaborately, the NCLT judgment itself. NCLT judgment.
8, 6 and 9.
Yes.
8.6, 8.9.
Yes. That is para 8, page 23 of the judgment, or it is page 6.
It was page 30 of your.
I am just giving it, Lordships. It is page 23, internal page. It is page 86 of my application.
This is in the, it's 261. No, 86.
Yes, page 86.
Right.
Para 8, the first issue.
Yes.
Whether the CIRP can be initiated against corporate debtor or state government company. Now my submission is this. The NCLT has applied its mind one way or the other and said we have jurisdiction. The best way and the only way, if you are aggrieved by this finding, is to go under 61.
Yes, we've seen that.
Because this is not an issue that the NCLT has skirted answering. It has elaborately dealt with it. So therefore we are saying to abandon
there's the same judgment there before NCLT, this SEC.
Yes, I am.
The same judgment that placed there.
Hindustan Construction, I am coming to that, Lordship. I have to deal with that because that is the bedrock of their argument.
Yes.
So I will place the judgment, why the judgment is not applicable in this, because I know that judgment was placed before your Lordships also. So therefore we are saying, instead of going to NCLT, coming to the writ court on the premise that the NCLT has no jurisdiction, we believe is an abuse of the process of law. Now Lordships will come to my para 5 where I am dealing with Hindustan Constructions. Please, Lordship will kindly take up Hindustan Constructions. Because what is to be seen in Hindustan Constructions are some very important paragraphs. आप लोग SCC नहीं लेके आते हो क्या? ये SCC तो है नहीं. 2020 does the court have SCC here?
Yes, we have. But you can this beforehand. You could have got it.
I'll hand over that. So this 2020 17 SCC, page 324.
I think Mr. Goswami would help me to read this print.
In the meantime, if I can rely on
get the book.
2020
17
SCC.
17 SCC.
Then I am just skipping submission 5. Let me come to submission 6 in the meantime, so that the court is not detained. Embassy property. Can you also get 2020-13 SCC?
You have a local counsel here, Mr. Goswami?
Yeah, we have. Mr. Purkashta, where is it?
Or you should have, prior information, you would have brought the books.
Sorry, I didn't know that. 2020-17 SCC.
But that is HCC, yes.
चाहिए ले आइए लाइब्रेरी से कहीं से एम्बेसी प्रॉपर्टी ले आइए I'm sorry, Lordships. Actually, I got the SCC, but the printout was of some other citation. I didn't cross-check actually. So, what we are saying is, embassy property, DJ. This embassy property is 2000. It says I am going to my sixth submission.
Section 61.
Yes, when an efficacious alternative remedy is available under 61 of the IBC 2016, this court may perhaps not entertain this writ petition. It is settled law that normally when a statutory forum is created for redressal of grievances, the writ petition should not be entertained. And this is precisely what was held in embassy property, because embassy property also arose from NCLT. And there also in the Karnataka High Court, the NCLT order was challenged. Of course, in that case, the challenge was upheld. Because in that case, the Supreme Court said the NCLT actually did not have jurisdiction. So therefore, the writ petition. In that context, the law was laid down that in what circumstances you can go. Now, would Lordship kindly have a look at this embassy properties. 2020-13 SCC, page 308. And would Lordships kindly come to para 10 first? That the first question that has been called out by the court. This para 10, question 1.
Yes.
In the backdrop of the facts narrated and in light of the rival contentions extracted above, the first question that arises for consideration is whether the High Court ought to interfere under Article 226, 227 of the Constitution with an order passed by NCLT in a proceeding under IBC 2016, despite the availability of a statutory alternative remedy appeal to NCLT. This is precisely the question that is before your Lordships today.
Yes.
Now the answer is, then Lordship will come to para 11.
Yes.
Para 11, I am just reading the from para 11 I am reading, it is beyond any pale. And Lordship is there?
Yes. Yes.
It is beyond any pale of doubt that the IBC 2016 is a complete code in itself.
Yes.
It is an exhaustive code on the subject matter of insolvency in relation to corporate entities and others. It is also true that IBC 2016 is a single unified umbrella code covering the entire gamut of law relating to insolvency resolution of corporate persons and others in a time-bound manner. The code provides for three-tier mechanism, namely 1. The NCLT, which is the adjudicating authority, 2. The NCLT, which is the appellate authority, and 3. This court as the final authority for dealing with all issues that may arise in relation to the reorganization and insolvency resolution of corporate persons. Insofar as insolvency resolution of corporate debtors and personal guarantors are concerned, an order passed by NCLT is appealable to NCLT under section 61 of the IBC 2016, and the orders of the NCLT are amenable to the appellate jurisdiction of this court under section 62. It is in this context that the action of the state of Karnataka in bypassing the remedy of appeal to NCLT and the act of the High Court in entertaining the writ petition against the order of NCLT are being questioned. Now Lordship will come to para 24 and 25. This is, having discussed the law and all other aspects, now see the conclusion of the three-judge bench of the Supreme Court. Therefore, Lordship, para 24, yes. Therefore, insofar as the question of exercise of the power conferred by Article 226, despite the availability of a statutory alternative remedy is concerned, ensiminic cannot be relied upon. Now, these 4 lines are important. The distinction between lack of jurisdiction and the wrongful exercise of available jurisdiction should certainly be taken into account by the High Court when 226 is sought to be invoked by busing a statutory remedy provided under the special statute. So what the court says is that there are two things. One is lack of jurisdiction and the other is wrongful exercise of available jurisdiction. So it is only when on the basis of this principle, let us now see whether the case of the state of Karnataka fell under category 1, that is lack of jurisdiction on part of NCLT to issue a direction in relation to a matter covered by the MMDR Act 1957 and the statutory rules issued, or number 2, mere wrongful exercise of a recognized jurisdiction, say for instance asking a wrong question or applying a wrong test or granting a wrong relief. So essentially the test is that when you come to the 226, if it is a wrongful exercise of jurisdiction, certainly you will not get into it. But well, if it's a lack of jurisdiction, an inherent lack of jurisdiction, then certainly it will come. And then para 46 is where it says, is the conclusion.
Yes.
Therefore, in fine, our answer to the first question would be that.
Reading from?
Para 46, Lordships.
46.
That is a conclusion on the first question of law they framed.
45.
Therefore, in fine.
Yes.
Therefore, in fine, our answer to the first question would be that NCLT did not have the jurisdiction to entertain an application against the government of Karnataka for a direction to execute supplemental lease deeds for the extension of mining lease. Since NCLT chose to exercise as jurisdiction not vested in it in law, the High Court of Karnataka was justified in entertaining the writ petition on the basis that NCLT was quorum non juris. So this is the test the Supreme Court has laid down, that when you have absolutely no jurisdiction, then of course.
Yes.
Has the book come, madam? Hindustan Constitution.
Is come here.
Now let me go back to Hindustan Corporation, Lordships.
Yes.
Kindly first come to para 2, because it's very important to note who were the parties. May I read? I am reading from the petitioner company, middle of para 2.
Yes. So para 2 is the fact relevant.
Yes. So Lordship has skipped the first few lines, then the lines start the petitioner company.
Yes, yes. Inter alia.
Yeah, I am reading from there.
Yeah.
The petitioner company inter alia undertakes these building projects as a contractor for government bodies such as National Highway Authority of India, that's the NHAI, respondent number 5 in the writ petition, please mark it, NHPC, that is respondent number 6, NTPC, respondent number 8, and IRCON International Limited, respondent number 7. Yes. Now please mark it, and the Public Works Department. So the respondents were NHAI, NHPC, NTPC, IRCON and Public Works Department. Now will Lordship kindly come to para 24. Because here the Union of India concedes that except for NHAI, all the other companies would be subsumed by IBC because they are government companies. So far as NHAI is concerned, Shri Mehta referred to the statement of objects and reasons of the NHAI Act 1988 and some sections of the Act to show that NHAI is a statutory body which functions in an extended limb of the central government and which is to carry out the sovereign functions of laying down national highways. Obviously, IBC cannot be used against such a statutory body because no resolution professional or private individual can take over the management of such body as it performs sovereign functions, nor can such body be driven to insolvency under the Insolvency Code. This was the argument made by the Union of India. The argument was only with respect to NHAI. Please, I am emphasizing on this. Now come to the findings and conclusions at para 70. Para 70. 70 continues.
Yes.
As correctly argued by the learned Solicitor General Shri Tushar Mehta, the first part of corporate person as defined in section 3(7) of the Insolvency Code means a company as defined in clause 20 of section 2 of the Companies Act. Section 220 and 245 of the Companies Act, which define company and government company respectively, are set out herein below. I have already taken to Lordship definition. Now in the next paragraph. From a reading of the aforesaid definition, Shri Tushar Mehta is clearly right in stating that the three entities who own monies under the arbitral awards to the petitioner, being government companies, would be subsumed within the first part of the definition. That is what was required to be shown. However, so far as NHI is concerned, Dr. Singhvi's argument of either deleting certain words in section 3(7) of the Insolvency Code or adding certain words to section 323G of the Insolvency Code cannot be accepted. So what they say is that NTPC, NHPC, IRCON, they are all government companies. So they would be subsumed. But with respect to NHAI, which is a statutory body, and with respect to those three petitioners, I have just, for your Lordship's consideration, if Lordships will kindly come back to the para 2 of that judgment. Para 2 of the judgment. First is National Highways Authority, NHAI. Now,
Act of Parliament.
Yeah.
Yes.
And then Lordship will see the third page.
Yes.
NHPC is what? It's a government company. If I can just point out that. This is a private placement of so-and-so under section 42 of the Companies Act. So they are a government company. Then Lordship will turn over the page.
NTPC.
NTPC, again a government company.
Identical.
All government companies. So therefore, and IRCON is the last page, again a government company.
Yes.
So the union also says that these three would be subsumed by IPC, but not NHAI. So therefore, Hindustan Construction is only applicable if you are a statutory corporation,
yes,
which is not the case with the petitioner here. It itself is an admitted case, is a record. It is under the Companies Act. So therefore, will Lordship kindly come to para 71. I have read 70. Now will Lordship come to para 71. Sorry, 70 I have already read. 72.
Yes.
It is clear from a reading of the Statement of Objects and Reasons of the NHAI Act that the development and maintenance of national highway is a government function that falls within Schedule 7, List 1, Entry 23 of the Constitution of India. So it's an absolutely different activity altogether. And most importantly, the distinctive feature is these are all government companies, and NHI is a creature of a statute, parliamentary statute. And then it goes into the, then the court goes into the act of, and then come to para 76, Lordships, is the final conclusion. Para 76, may I place it. From a conspectus of the above provisions, it deals with the whole act. What is clear is that NHI is a statutory body which functions as an extended limb of the central government and performs governmental functions which obviously cannot be taken over by a resolution professional under IBC or by any other corporate body. Nor can such authority ultimately be wound up under IBC. For all these reasons, it is not possible to accede to Dr. Singhvi's argument to read in or read down the definition of corporate person in section 3(7) of the Insolvency Code. This is the final conclusion, that with respect to NHI, nothing doing. You cannot initiate IBC. But with respect to other three, even the union accepts that position. Now, having seen this, Lordships, would Lordships kindly have a look at Whirlpool? It's a very celebrated judgment, Lordships.
Well, it's everywhere. It's set out the guidelines.
The guidelines, Lordships. It's a very, very celebrated judgment. I'll just para 15 and 20, Lordship, may just make a mark. I'll just read para 15 for my benefit, Lordships. It's always nice to refresh, Lordships. Para 15. Under Article, Lordships, para 15, Lordships.
Yeah.
Under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. But the High Court has imposed upon itself certain restrictions, one of which is that if an effective and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has been consistently held by this court not to operate as a bar in at least 3 contingencies, namely, where the writ petition has been filed for enforcement of any of the fundamental rights, or where there has been violation of the principles of natural justice, or where the order of proceedings are wholly without jurisdiction or the bias of the act is challenged. None of these, with respect, exist in the instant list. They have been heard. There was no violation of natural justice. They are not challenging any act. This is a case where the NCLT clearly in jurisdiction, and the only alternative. So, in these circumstances, Lordships, it is my humble submission that Lordship will vacate this order.
Can you make the application by tomorrow?
Yes.
The arguments by tomorrow?
Yes.
Or the after will be difficult. Yes.
Your Lordship, the application has been listed for this application vacating stay is listed for hearing today, my lord. Kindly give me 2 days time, my lord, and your Lordship.
The after will be difficult because the swearing in is there and the whole day will go.
9th.
We'll have it on.
9th.
9th will be good.
9th will be Monday, your Lordship, because 8th that.
No, I'll tell you why, Lordship. There is an issue here. This I need to point that out to AG also. This is a petition under 2263.
Yeah, 2 weeks, but then there's a fresh application.
No, but it goes from time of filing. That is the language.
No, that is fine, but no, that will not take into account.
Okay, so 9th is okay for him, Lordships.
9th or 10th.
10th is also fine, my lord.
10th is fine.
Yes, my lord.
We'll make some time on the 10th. Yes. Yes.
Your Lordship may have it on 13th also if it is not inconvenient to my friend, because my lord, what has happened that one important matter of state of Meghalaya is listed on 8th before Godavarman bench, my lord, regarding ban on mining in Meghalaya, entire ban, entire everything, my lord. So that case is, and we have to file reply by tomorrow. So therefore, if my friend can accommodate me.
No, you request, see, the court's always here. It's between you 2 senior counsels. If you want on the 10th or the 13th, yes.
1 minute.
Then you just come back with a date. It'll either be 10th or 13th. You inform the court master. Yes.
No, he is in Delhi, Lordships.
No, my friend will heard Ms. M. Goswami was completed his arguments on vacating the interim order. That is 49 was 49, right? 25. Sorry, yes. List for further. For replies on dash. We'll leave it blank. You just contact him and fill it up.
One submission, because we have to file reply to the application. We'll file reply.
Replies to applications should be.
In fact, now that we have demonstrated amply clearly that the court will, I believe, Lordship will dispose of the writ petition itself. Because
yes, you keep your cards hidden. Yes,
and I reserve the right to reply once.
Of course.
So can it be kept at 2 o'clock on Monday if it's convenient for him?
See, only one problem is that so we don't know with the new CJ coming with the roster might change.
No, but they then keep it part-heard, Lordships. Lordship will have to. Lordship will keep it part-heard.
We keep part-heard.
Part-heard and Monday 2 Lordships.
At 2? Yeah. Okay, yes.
No, Lordship, because now yesterday Lordship from Jorabat, Khanapara to Jorabat took us 2.5 hours.
Why is it raining?
Yes, there was and from Khanapara to Jorabat, it took 2.5 hours to fly from Delhi to Guwahati, and from Khanapara to Jorabat 2.5 hours, Lordships.
So that issue of mining becomes very important. That they having to Supreme Court. The issue regarding mining in Meghalaya. Yes, 2 o'clock.
Hearing
at the request of Ms.
13th, 2 o'clock. Is it okay for the AG?
Yes.
Can be here personally.
Yes.
Yes.
Part-heard, Lordships, keep it part-heard. Well, I'm so grateful. I'm very, very grateful, Lordships.
Yes, MS.
Your Lordship, this matter was last listed on 3rd September. This court has given liberty to file written submissions, though it is not reflected in the order. There was
Pathak had to show the. He had to. It was Mr. Paul and Mr. Pathak
Mr. Pathak.
had to show. What did he have to show?
Mr. Paul had to show.
Mr. Paul had to show that how they still aggrieved.
Lordship. And in item 20, Lordship was
And this
supposed
an
to
item,
file
and in your item
submission.
20,
And 20, we were supposed to file written submission.
is that correct?
Yes, Lordship.
And where's the submission?
Here, Your Lordship. I have given them copy.
Yes, sir.
This is yours.
So no more arguments to be made.
Lordship, this matter may be fixed after 2 weeks, Your Lordship, as requested by Mr. Pathak, Your Lordship.
So the court has to go by the orders of Mr. Pathak.
No, this is a request, Lordship.
Yes, written submissions have been filed by the counsel for the petitioner. Our request has been made that the oral arguments also be allowed to be made after 2 weeks.
Yes, Lordship.
Only after 2 weeks, yes.
Deeply obliged, Lordship.
Where's Mr. Paul? Who's appearing?
22.
Lordship, Mr. Paul is having some personal difficulties today, Lordship.
No, but
Lordship, in this matter, they're supposed to file additional affidavit.
Lordship, I'm not the briefing counsel on this matter, Your Lordship.
doesn't matter. 21, 22. It's 21, correct?
Lordship.
We'll listen after 2 weeks. You file additional affidavit, then you just inform us. List this matter together with so and so after 2 weeks. Yes. Additional affidavit, if any, to be filed before the next date.
Obliged, Lordship.
Yes.
22.
Lordship, I'm paying for 2 weeks' time on this matter, Lordship.
22. Ira Raj, where's the respondent? MS Barachaji?
Lordship.
Oh, she's on leave, I think. Nice. Can you just check?
Yes, sir.
Till
8. Till 8. 8 of October.
this is matter after 1 week.
Deeply obliged, Lordship.
As the council or council for state respondent is on leave. Yes.
23.
May it please, Your Lordship.
Yes.
Your Lordship, in this matter, Ms. N.G. Shilla, the conducting counsel, she is not available, Your Lordship.
You have no objection?
No objection.
When?
After a week, Your Lordship.
After 1 week.
Your Lordship.
Much obliged,
Highly
Lordship.
obliged.
My lord, that electricity matter interim order to continue till next week.
Yes.
26.
So the hearing in the main case tomorrow.
May I please, Your Lordship?
Where's the arguing counsel? He's here. This is transfer matter.
Not my lord, financial benefits, my lord.
Yes, Mr. Start.
Okay, my lord, the petitioner before Your Lordship is a retired professor of Nehu. He was retired on 30/6/2023, my lord. My lord, during his service period, my lord, a PS case was registered, an FIR was registered against this petitioner, my lord, and on the basis of that FIR, the petitioner was suspended, my lord. Thereafter, the petitioner approached this honorable court, my lord.
What was the charge?
Charge was harassment, my lord. Only there was some actually message during late night. There was messaging. That was the allegation only. Whatever, my lord. Thereafter, not arrested.
Just DP.
Only.
Then what happened?
Then, my lord, this honorable court was pleased to direct the authority to reinstate the petitioner from his in his service, my lord. Thereafter, my lord, his service was reinstated, my lord, and he was continued his service, my lord.
Where the order is stating him?
Reinstated order is there, my lord. It's at page 42, my lord. No, my lord. 30, page 30, my lord. Of my petition, my lord.
Page 30.
Page 30.
Where's the High Court order? Where's the order of this court reinstating him?
High Court order, my lord.
Was reinstated during the pendency of the Department of Proceedings?
Yes.
It's just statutory. He was reinstated.
Yes, my lord.
No review or suspension was done.
Thereafter, my lord, in the trial court, my lord, that FIR was charge sheeted, my lord, and that in that case, my lord, the informant compounded file a petition to compound the case, my lord.
Yeah.
And in that case, my lord, he was acquitted, my lord. Thereafter, the present petitioner filed a petition, filed a representation before the authority, my lord, before the authority, my lord.
Then what happened?
To stop the departmental proceeding, my lord, because in the meantime, my lord, the petitioner was superannuated, my lord, due to his age, my lord. Thereafter, my lord, that representation is at page 42, my lord.
You superannuated when? Which date?
On 36 2023, 30 June. My lord, thereafter, the respondent authority, my lord, stopped the departmental proceeding, my lord, on the basis of the representation, my lord. But there was another prayer, my lord, to treat the suspended period as on duty period, my lord, and to release the increment, my lord. The increment of 2018 and the financial.
The prayer to make it as on. What are you saying just now? The prayer to treat it on leave. Was
Yes,
it
my
rejected
lord.
or allowed?
To treat the period of suspension as on duty, my lord.
Was on duty. Was it rejected or allowed?
That was rejected, my lord. That was rejected, and that impugn order is at page, my lord. Relevant portion is at page 52, my lord. The last part, my lord.
Yeah.
The council was apprised that the executive council in its 186 meeting held that on 18 March so and so by resolution letter so and so resolved that the status quo maintain so and so so and so. The next line, next paragraph, the legal officer by letter dated legal so and so so and so has submitted the comment. The comment of the legal officer was read out before the council. The council deliberated on the matter. The council resolved to regret the request of Professor Srivastava to treat the period under suspension as period in service and for grant of increment in
So you are asking for that period now to be given the increments and
yes, yes, my lord.
Prayer and
That was the prayer, my lord.
How do you see you entitled to it?
Yes, my lord. On the last occasion, my lord.
Why you saying how you entitled to it?
Yes, yes, my lord. Since he was acquitted, my lord.
Not honorably acquitted.
My lord, that case was compounded, my lord.
Compounding is different.
Compounding as per section 320 and subsection 8, my lord, it amounts to acquittal, my lord.
Acquittal might be acquittal, but
yes,
it depends on what kind of acquittal it is. Anyway, continue.
Since he was acquitted, my lord,
yes,
and no case is pending against him, departmental proceeding is also stopped, my lord, against him.
Yes.
So and this order was also not passed in the departmental proceeding, my lord. So subsequent thereto, my lord, it amounts to punishment, my lord, because stopping of non-granting of the increment of 2018 and not treating the period of suspension as per as on duty, my lord. It amounts to punishment, my lord, and I am getting the punishment, my lord, without any fault on my part, my lord.
Hmm. Okay, yes. Where are the authorities?
Nehu authorities.
No, where are the authorities in support of your case? Regarding what kind of acquittal?
Regarding acquittal, my lord, that is in my petition.
No, regarding you got any law supporting your submissions?
Lord, as per fundamental rule and subsidiary rule, my lord, 54, my lord. If the person, my lord, I am reading the relevant version, my lord.
The facts you stated, yes. Now show the law to support your case that you have a right to, that your rights have been violated in the sense that your service benefits have not been given. Where's the law?
My lord, for the rule 54, my lord, 54B, rules deals with the treatment to be given to the government servant who is reinstated after having been suspended. The competent authority has been vested with the power to pass an order as to how the
pleading regarding FR 54 in your writ petition.
In my writ petition,
where are you basing your claims on? Only on the fact of acquittal.
Only on the
compounding the offence.
Yes, my lord. Since
all. Now, where have you made the pleadings that in the event of such thing has happened, why are you entitled to it, and why did deprivation or the rejection of your prayer by the Nehu is unjustified and illegal? That's the basis. That's how you.
Yes, my lord. In the earlier
also, done your pleadings.
My lord, on the earlier occasion, my lord, I had filed another writ petition, my lord.
Earlier occasion, we're not concerned what happened before.
Yes, my lord.
We're concerned what materials and pleadings are here before this court today.
Yes, my lord. Because the 187 meeting of the executive council where the prayer of the petition was not.
Why do you say that
it is not in accordance with law, my lord?
Legal? Let's see your submission.
Yes.
Let's see your ground. See. Where is it? Where have you made any submissions on law? That the rejection of your prayer is illegal. Where is it? In your pleadings.
It's not on my pleading.
Then you all know that your facts come first and law follows the facts. And if you're coming to a court of law,
yes, my lord,
you have praised the facts, and now you have to follow up with the law that your rejection is the rejection by Nehu is illegal.
Yes, my lord.
Now show the law.
My lord, on the last occasion only we could know, because on the last occasion, my lord.
Your name?
My lord, Rashid, my lord.
How long you practiced? How long you have been practicing?
My lord, 10 years, my lord.
10 years?
Yes, my lord. My lord, on the last occasion, my lord, I was on the point, my lord, that since the respondent authority has passed the order on the basis of the comment of the legal officer, but that comment was not. What was that comment? That was not communicated to the petitioner. On the last occasion only, on the direction of the court only, they have submitted the comment of the law officer, my lord.
What is the comment?
That comment was also not. That was on the last date. They have submitted.
What set is with your lordship? The lordship wanted to see, because based on the legal comments, so there is a detail we have referred to the relevant, my lord, FR, SR, everything.
Have you put it in affidavit?
No, my lord, only submitted.
The lordship has asked me to give him the copies. I have given him the copies also.
Not the entire copy, only few.
Legal opinion, my lord. What you wanted, the legal opinion we have.
This is the second. This is the first.
What do you have to say to this, to the decision taken? You've got the copies.
I got the copy, my lord.
Then?
My lord, on the
but not
as
affidavit.
per their
No, no, my lord.
not the
We have given him lordship. Lordship wanted to see the records, my lord, relevant records pertaining, because in the executive council decision, my lord, our decision is this: we are unable to exceed his request, and we considered the legal opinion in the matter submitted before the EC. And after considering this, his prayer was rejected. So, my lord, while perusing this, lordship just wanted to see, my lord, that part of the records. So I placed this on the records. Now, if your lordship look into the legal opinions, my lord, every provision of law, my lord, FR, SR, everything has been referred to. Here is the fact, my lord, it was compounded, your lordships. He was not on duty. Another thing, my lord, we will look into it. This case was filed after he retired from service. So retirement, my lords, everything ends, my lord. How it is maintainable after retirement?
Exactly, he has to come with the law, that's what. You submitted that application of section 320 of the CRPC, right, that time?
yes.
You submitted to the, you give copy to the respondents.
Yes, my lord.
Copy is given.
Yes, my lord. Copy was given in
320 application. Only the order of the trial court.
Order and the statement of the
Now what about
complainant.
this application made?
I got the certified copy of the order and the order copy of the trial court and the statement of the complainant. That was communicated to them. That was along with the representation, my lord. That is at page 50, my lord.
Show the law. You do research, come back. You've seen what is said here. We'll have another opportunity. Look up the law. When an offence is compounded, and what kind of compounding? Whether a trial is on merit or when it's compounded, what? Suppose a trial is over and it's found that he's acquitted honorably, right?
Yes.
Then in those instances, then the authorities have to examine the order of trial court. Okay. Then they will find that so his suspension was unjustified. So if they find that the suspension is unjustified, then they will restore whatever benefits he's to get.
Yes.
That decision they have to take. Correct. In this case, I think they've taken a decision. I'm not gone through that. That's the acquittal was not on merit.
Yes, that was
on compounding. So what will be the impact on your case? You do some research. You're from Shillong.
No, my lord.
Very good. Then you do some research. Come back. Give you 2 weeks time. You're Mr.
A. Rashid.
Mr. A. Rashid today was allowed for 2 weeks time to come with authorities. Remember the difference, okay?
Okay, madam.
Yes. If the trial court has acquitted you honorably, that there was no material against you and you were suspended wrongfully, then that suspension is unjustified. So justified, then you're entitled to all your benefits. But if in this case there's been a complaint of sexual harassment, then the trial court was proceeding, then why in the course of the trial, then the complainant came forward, didn't want to pursue the matter and compounded. I think 506 was compoundable and the other section. So fine. So So that's why the trial was closed.
Yes.
So in that instance, whether you'll be entitled to your past benefits, that's the only thing. You understand?
Understand.
Yes.
Oblige, Your Lordship.
28.
Next. Yes, you ready with the matter?
No, Lordship. Can you have this matter for 2 weeks, Lordship?
Why?
Personal security of the Army Council, Lordship.
He's retired.
Yes, he is retired.
Yes, sir. Yes,
Why all these retired people filing cases? Why are you filing when in service?
Yes, Lordship.
When you file in service, there's some urgency to the matter. You're retired, then yes. It should not be your hobby. You should be, fighting for your rights. Yes. At the request of Mr. Lasongaya, we are the petitioner. This is the matter after
2 weeks, Lordship.
2 weeks.
Oblige, Lordship.
29.
Yes, you have to come up something, Mr. Yubin.
My lord, the disputed facts, my lord, can be entertained, my lord.
No, these are back. Only one thing we concern you, disputed facts also, where in the course of when the arrived decision, whether any notice at all is given to the petitioner.
My lord, there's a constructive notice that was given to him, my lord. I'll just show two documents, my lord, that will be very clear, my lord. May I take, my lord, to the counter affidavit filed by the respondent number 3, my lord?
1 second.
Just 2 documents, my lord. This will be very clear.
Who's number 3?
Number 3 is the CEM, my lord.
Sora.
CEM of Sora, yes, my lord. Because this will prove that there was a notice on him. Of course, there was no direct notice named personally to him, but there's a constructive notice.
What do you mean constructive notice?
My lord, because the Sordar, my lord, the Sordar was a party to this order, my lord. There's a proceedings.
Filed by
Respondent number 3, my lord.
Yes.
The Khasi order is page 66 is the Khasi order, my lord.
Of the affidavit, page 66.
My lord, page 66 of the counter, my lord. No. Yeah, page 66.
Yes.
I'm sorry, my lord. Page 24 is a translated copy. Not 60, 24. Page 24, my lord.
Constructive notice.
My lord, this is the page 24 of the counter, my lord.
That's for number 3.
Yes, my lord.
Yes.
My lord, may I read, my lord? It's a short order. The allotment of land by the Sorder of Nongsteng
Short order is very long, yes.
to a private individual outsider within the jurisdiction of Nongsteng Traditional Administration. Summary. In connection with a matter of complaint received in this office from the President and the General Secretary of the Unitribe National People's Movement dated 2nd August 2016.
You been a party? This HNMP something?
No, my lord.
They are not a party here, my lord. He has not made a party, my
Who
lord.
are they?
My lord, they are some
body NGO.
A defunct NGO, my lord.
Some NGOs. Whatever may be the case, my lord, it was brought by this organization. This was brought to the CM's notice, man, that the Sorder is in violation of his sanat, has allotted to somebody else. So that's a thing, my lord. So now, in response, second paragraph, in response to this letter number dated 2nd August 2016, wrote to the Sorder of Nongsten, instructing him to appear in person at the office on 13th August 2016 along with leaders of the said organization to clarify the matter. The Sorder responded in writing via a letter dated 6th August 2016. In his reply, the Sorder of Nongsten opposed the content of the news report published in Rupang, Nongsain Hima and Maupor newspapers. He stated that he had never heard of Unitribe National People's Movement before. He also alleged that the said organization had interfered in the affairs of the Hima Sima and the Dorbar of Nongsten without any authority. He argued that they had no right to intervene in the village administrative process and decisions of the Dorbar Nongsten. The organization made accusations without knowing the facts or understanding the deliberations of the Dorbar before arriving at a decision to allot the land. The Sordar clarified that the Dorbar Nongsten had convened several meetings before taking the decision to allot the land to the individual. It was not done arbitrarily as alleged. He further stated that only a few individuals from the organization were involved in interfering with the village administration. The Sordar urged the CM not to listen to or allow such organizations to damage the social fabric. He assured that as the Sordar of Nongsten, he would never act in violation of the authority of the Dorbar CM as per clause 1, 2, 5 and 6, but rather his actions and that of the Dorbar would only strengthen the authority of both Nongsten Dorbar and the Dorbar CM. The Sordar also revealed that the person to whom the land was allotted was not an outsider, Nepali or Bihari, but a true Khasi whose family originated from Rewar. The Sordar requested the office to immediately dismiss the baseless allegations and complaint of the said organization. Another letter was received from this office from a group of village elders from Nongsten dated 8 of August 2016, signed by 14 individuals expressing the support to the HNPM and agreeing that a complaint against Sordar was valid and truthful. They expressed opposition to the Sordar's action, alleging that he had violated the Dorbar Pulun General Assembly, which is usually held annually. They appealed to the CM to take necessary action against the Sordar. Following this, the office, through letter number so and so dated 10th August 2016, again instructed
Show me where, show the court where is
Yes.
the notice given to
So-
the petitioner.
No,
to
my
the
lord.
beneficiary of this Darbar resolution of this Darbar Nongsten.
My lord, then,
Nongsten or something.
my lord, towards the end, the decision, my lord, I'll just
No, no,
take
sure.
after this decision, I'll show, my lord, which is what there.
This is but only thing is that 2016 decision is on.
Yes, now this decision was of 29 October 2016, wherein this order has revoked the agreement
What
given to
happened
him.
after this order?
Now after this order, my lord, kindly this page 67, my
Just
lord.
give this court a sequence of events.
Page 67.
Like now 16 it was revoked. You
Yes.
had no knowledge about it.
Yes.
Okay.
Now page
Then
67.
When did you finally come to knowledge about that?
Page
this
67,
rules
my
been
lord.
cancelled?
Page 67 of this, my lord. Page 67. Page 67, my lord, of this order. Now,
Dated when?
page 67, 1st November 2016, my lord. 1st November
He was
2016.
informed.
Yes. Now, office of the same, we said, to the Sordar of Nongsten. He is the one, is a subject to announce the resolution regarding the allotment of land to a private individual.
Who's the
from-
beneficiary of Nongsten here?
He himself, I'm appearing because now I am the present
No, the person who was granted.
no, he's no more.
He's deceased, my lord.
He's deceased, my lord. But at this point of time, 1st November, he was very much the Sordar at that relevant point of time, my lord. Now he's given to the Sordar of Nongsten.
Now do you have the records of Darbar whereby he allotted the land?
My lord, that
Have
is
you brought an affidavit?
no, that is not there. That is the problem, my lord. That is not there, my lord. Because
I think you'll have to
There-
have a
there-
fresh look at the entire matter.
Yes, my lord.
that is
Detailed hearing, my lord.
that is a reason why.
You'll hear- Because only court wants to know
Yes,
as to when did the petitioner
yes,
came to the knowledge
yes.
that the allotment of land in his favor had been cancelled. That's the only thing.
Well, this on 1st November 2016, my lord, the decision will officially announced on 4th November 2016. He is presumed.
Where if they had the courtesy,
Yes,
the CM Sora,
yes.
to put a copy to Ketlar Umdor, whoever he was a last Sordar Nongsten,
My lord, my lord.
and to this so-called Peasant Secretary Hinyotre Youth Movement, why didn't have the courtesy to give it to this person who was a subject matter of entire
My lord, we
controversy?
have given to my lord, the Sordar, the CM has already given issue to the Sordar, who has issued this agreement to allotted the land to the third party, my lord.
Does this Hinyotre national still exist? You bring them here before the court.
My lord, I have.
Do they exist?
And there are 14 individuals or so of the village elders, my
Are
lord.
they a registered organization? NGO?
My lord, the question here is, my lord,
put
it's
them in jail.
No, the importance here, my lord, how
Lord,
can
we
you
are
put them in
accusing
jail,
them,
my lord?
some of
He
the
himself
members-
is playing fraud, and when he's when he's playing fraud and when he's been caught, he is coming to get a premium from this honorable court, my lord. Because my lord has seen,
I don't think that's a fair submission.
Yes,
my lord.
A person who's been vested. See what happens when you vest something on a person.
My lord.
Vested with civil consequences. If that thing's taken away,
yes,
civil consequences will fall on him. Since visited civil consequences, and the decision was taken without hearing him at all. Suppose he was called the darbar, to what basis he was allotted the land, he could not justify it, maybe wrongful actions. Then at that point of time, he'll know as to where he stands.
Yes, my lord.
When did you come to knowledge first of cancellation?
10th of 4th of October 2024, when they sent the letter annexing a letter sent by respondent 3 annexing the decision of 2020-16. My lord, if my lord would have this.
My lord, his expenditure risk does not clear the title.
How much will pay him? Damages.
My lord, he has an alternative remedy, my lord, if his damages.
Not true, my lord.
And plus, my lord, when the agreement is it's void ab initio, my lord, is void ab initio, my
That
lord.
does not hold good.
My lord, because this is a
wrongful submission, my lord.
No, my
He's
lord.
not seeking enforcement of any agreement. He is just coming that whatever decision was taken by a recognized authority.
My lord,
without hearing him. That's all. Simple as that.
My
this court looks at what? It looks at whether it's a code of equity. That's all. Code of equity is that whether this person's been given a raw deal, it's been a fair deal.
My lord, equity. My lord, equity would not mean that if I got something illegally, my lord.
Why illegally?
If I got some, because here, my lord.
Mr. Yobin.
Yes, my lord.
It's not a question of you buying a stolen car. Remember that.
My lord. We approached their office.
It's not a question of you buying a stolen car and saying that or that he bought a stolen car and says that I don't know, the papers are all right, I purchased it, and now
my lord,
the police have come and seized the vehicle.
Today, my lord,
what rights will he have? Nothing.
My lord,
but
today,
then the things are suppose you enter the bona fide transaction.
No, bona fide transaction, whether
suppose,
yes,
just listen.
Yes,
you see a plot of land.
Yes.
Now you go through the darbar.
Yes.
That this plot you want to purchase it or they allot it to you.
Yes.
And in that belief, you take the allotment, you make investments, and one fine morning they tell you there was a decision taken 6 years ago that the person who was the recognized authority. I'm not saying that the person was unauthorized or did not have the authority. He is a Sardar at the point of time. He had authority in his own village.
My lord, this
how can you say that he got it illegally? How do you qualify your submission?
My lord, this Sardar does not have the authority to alienate
that he has obtained illegally.
My lord,
it can be irregularly, but how do you say illegally?
My lord,
irregular and illegal are two different things.
My lord, such a plot,
can be condoned.
My lord,
irregularity can be ironed out. Yes.
Such a big plot of land, my lord. Does anybody pay 30,000?
Don't bring common sense to think.
No. Here it's in the record, my lord. It is on record. He paid 30,000. 30,000. Look at this one. I said,
my lord, we donated to the office, my lord.
This is what.
Donated. Kind gesture.
Can you look what is it? Receive rupees 30,000 to Mr. C.C. Mesil today, 18th May 2016, as a donation to the village for the donation of land at Wakalia according to the boundary. 30,000 donation. In response to what? In response to that you have given me a land.
Yes.
30,000 donation and another 20,000.
Exactly, my lord.
And another 20,000, my lord.
Tomorrow you open, I decide to donate one house to you.
My lord, there will be.
Do I expect you to pay the price of the house?
No, my lord, I'll be the most happy to accept that.
I'll give you this house. Then you say, okay, fine. You come and give me, maybe some token. Can I say that? Can the common say how do you donate to Mr. Yobin? How he donated this house and he paid me 5 rupees? Can you say that?
No, but the thing is, my lord, the person.
Don't go there. But just come back to the base
but the
thing.
person, but the person.
What? How can you correct it?
But the person who donates must have some authority to donate, my lord. The Sanat itself says that I cannot.
See, if he was in the loop, okay,
yes, my lord.
That he was brought in the loop on 16.
Yes, my lord.
That look, Mr. Petitioner.
Yes.
Or whoever, you have irregularly been given.
Yes.
You know, this person.
This is what we are
Sardar
correcting
had
now.
started illegally.
Yes.
That that you've given you, he had no authority.
Yes.
Sorry, take back a 30,000 donation that given to the Shillong and go back home.
My
then
lord,
fine.
this is
Then
what
the court will not interfere.
Yes,
Whatever
my lord.
private dispute he might have with with the other respondents or whether it's right, then he can go and file a suit that the donation was done validly. But
Yes.
in this case, he was not heard at all. He was on a bona fide belief that no, the donation was valid. A bona fide belief that he invested money.
My lord, now the bona fide, how do he prove that bona fide, my lord? The bona fide has to be proved by trial.
Yes.
Therefore,
How do you correct it? You
my only
I'll give you one chance.
My, no, my,
How do you correct it?
My only
You give him a chance of hearing.
My only objection here is, my lord, my only objection here is I am not telling him, my lord, we are closing directly out of his redressals, my lord.
Mr. Yobin, we can't allow
Yes.
invitation institutions because even in the Khasi system is ingrained the right to be heard.
Yes, my lord. That's
ingrained. It's part of the, you can say,
Yes.
the
Yes.
DNA of the social engineering and social
Yes,
structure,
yes.
correct?
But that I bow down, my lord. But
Anything that happens, the person against who action sought is always called. Whether
Yes.
it might be like a kangaroo court also, but he's called and said
Yes.
we have something to say.
My lord. My lord,
in this case, you have not been able to show to the court that at any instance there has been a direct notice to him or that he's been informed.
no, that
Nothing.
I admit, my lord, that there is no notice directly
Yes,
to him from the
yes, what
CA,
is-
my lord.
Yes, Your Lordship. The crux of the matter is that the petition is agreed by a particular order which was issued by the office of the CA.
On 16.
Yes, Lordship.
Yes.
So what happened, Lordship? The series of events which followed that. Is
I can't. I think you better come this side. You're behind the camera.
Lordship, what followed the order dated 29/10/2016 is that there was an intimation to the Sardar and to the president of the NGO. Now, Lordship, how did all this start?
Why
All
did you
this-
intimate the writ petitioner?
Yes, Lordship. So I'm coming to that. So how did all of this start? All of this start, Lordship, based on a complaint given by the NGO to the CM. Now the NGO had mentioned that the Sardar had acted in contravention of his sanad. Now based on that, the Sardar was called for. He was called and a hearing had taken place. The right of being heard was taken place, Lordship. Now it had not specified to whom the land was given. It just specified that it was someone from outside the HEMA, Lordship. That is why there was no
complaint. Have you read the complaint of the NGO?
Yes, Lordship. The
Next year.
complaint of the NGO has
In
been
the
annexed in
affidavit?
my yes, Lordship.
Very good. Where is it?
It's in my affidavit at page number
Page.
at annexure 2, page number 15. Now the typed copy is at page number 17 and the translated copy is at 18. If I may read, Lordship. Page number 18 of my affidavit. We, the leaders of the
Where's the Khasi copy?
the Khasi version is at page number 16, Lordship. It's in handwriting. So the typed copy is at page 17.
Yeah. So you mean to say,
so based
that
on
after
this,
he got this complaint,
yes,
he did not
Lordship.
any inquiries whom was sold or who got
That's why, Lordship, the Sardar was called for. The Sardar had been
didn't
called.
inform.
No, Lordship, the Sardar
That means
had
he
been
didn't
called.
inform that it was given to person ABC.
No, Lordship, that was kept. That was kept. If you look at the,
Part of the records, my
if we look at the
In
RAI,
the summary, my lord, it's been part of the records that
If we look at
agreement
the
was
RAI,
made.
I just want to see whether he's given your name.
there's no name, Lordship. There's no name. It's always someone from outside the HEMA, based on the complaint given by the HNPM, and based on the intimations and the correspondences with the ex Sardar as well, with the deceased Sardar. The district council, the executive committee of the district council was also apprised of this matter, Lordship. And based on that, we had forwarded the 2016 decision to the district council, and the district council was pleased to.
I think you are
state
aware
that.
of in the decisions after in the regard to a private person. I don't understand. The court doesn't understand any. How is it possible that the person affected is not revealed to, and also the went ahead with the decision?
Lordship, it was actually supposed to be the responsibility of the Sardar to intimate to whom he had given Lordship of the decision.
So you believe, so even if that matter for him, that means on the complaint it was taken as gospel truth.
Lordship, we had called for a hearing based on that complaint. We had called the Seng Bhalang, we had called the Shnong and other members as well of the Shnong. That's why the decision at page number, that's why the announcement or the pronouncement out of the Rai, which is at page number 64, sorry Lordship, at page 65, that was given, Lordship. And that decision was supposed to be announced in public as well. So we have no idea who that person was. But the main agreement of the people of that area is that the land was allocated to someone.
That, that is not known.
My lord, following this letter, 1st November 2016, the Dorbar of the Sardar, my lord, they issued a confirmation letter on 5 January 2017, confirming the land has been given to us. It's part of my repetition.
That is 816 page 54. Who wrote it?
Lordship.
My lord, this is the second complaint given by the Sardar in person, my lord.
Yes.
This was in 2017. My lord.
Now if we go to page 60 as well, Lordship.
And you also kept quiet.
Lord, we were not aware
of the whole thing happening.
Not at all, my lord.
It is an admitted fact. It is an admitted fact, Lordship, that
we did not
in his writ petition, that he had been facing trouble. That's why the work was delayed as well.
Trouble and so notice is different. Two different things.
If there were troubles in the village itself, the villagers would have informed, and he was open to come before us
in 2022. My lord, alleging the same.
He was open to come to us, Lordship, to address such grievances.
No, what Mr. Ames correct also. There's no reference to any name here by the Sardar.
Yes, Lordship. At page 60 as well, there's another letter, a representation from correspondence from the Sardar.
My lord, it's a unique case for your lordships to adjudicate upon, my lord. Detailed hearing will be required, my lord. I have to take your lordships to all the actual aspects, my lord. Otherwise, also, my lord, if my lord would grant me some time, my lord, I'll take your lordships
to all. It's not a question of granting some time. It's a question of we don't need to go for detailed hearing. This is a question of whether you were in the, whether you had any knowledge. According to no knowledge, according to them also they had no knowledge.
Well, we had none.
We have no knowledge of cancellation. They have no knowledge about the person. So who's groping the dark?
Lord,
it's the deceased person, Lordship. The deceased person.
The deceased person.
So his reprieve, yes, Lordship. His reprieve is only with the deceased person now, Lordship.
Who was in office?
So, Lordship, they were open to so many other remedies to approach us, to come. After approaching us, we've sent the Sardar. The Sardar has asked him to produce the documents.
Sent representations in 2022 or 2023 and 2024. About 5 representations, my lord. They've not replied to one.
Now, what is the convention or can the Sardar allot land, donate land?
No, Lordship.
Yes,
no, Lordship.
He can give
the land.
This petitioner is not a non-tribal, my lord. He's a Khasi as much as
can he donate?
No, Lordship. He cannot. Now
I donate to anybody.
My lord, no, my
lord. Yes, my lord. There's a current complaint in the KCDC
the
giving to the government, my lord, against respondent number 1.
For my own villagers, my lord, who are original, I have the power, but not to outsiders.
Outsiders.
Was a person from other village adjoining.
No, Lordship. Only within the HEMA itself. That is only within the HEMA.
Discrimination, my lord.
No, Lordship. That is a customary practice.
Because we are all from the same district.
They'll not give if we are not.
Nonetheless, my lord, the law provides that we shall be equal in the eyes of law. They are Khasi as much as we are.
No, no,
we
no,
hold
that-
an
that's
ST
one-
certificate as much as we have.
He is questioning the very fabric of customary practices.
Even that's they never followed their customs and traditions while following this procedure itself, my lord. They ignored the principle of natural justice. They violated the constitutional rights
not
of the petitioner.
violate the grassroots
How is this
democracy prevalent
part of
in the
tradition, my
HEMA, lordship.
How can this be termed as part of the customs and tradition, my lord? Violating the principle or the petitioner's constitutional rights.
For your convention. That we know, yes.
The convention, yes, lordship, it is there in my affidavit, and I have also annexed the sanad as well.
Where
The sanad at page number of the Rangbash of the Sordar Shnong, lordship. It is at page numbers. It is at page number 11, lordship, and the.
Yeah, let's see what it says. What are the conditions?
It is the conditions, the relevant conditions are at 3 and 4, lordship, of an extra 1 of my affidavit.
The only difficulty here is that you don't have the records at all. No records, Mr. Juben,
My
or
lord,
are you
I-
concealing them?
My lord, I have not proceeded against him anything, my lord, because when I came to know, when I became the Sordar, my lord, I wanted all the reports, all the partners.
So when you succeeded the earlier incumbent still alive?
Yes, my lord.
My lord,
Yes, my lord.
when I became the Sordar, my lord, and my executives, my lord, we have got some documents, my lord, but regarding this particular lord, my lord, we found nothing. That is the reason, my lord, we have to issue a legal notice to the secretary who is alive. We have issued a legal notice also. Why are you hiding? Bring everything.
The
So
documents
there's
are
some fishy.
still around, you mean?
My lord, there's something fishy. It's not everything right, my lord. And my job was, my lord, my job was just to point out.
My lord,
You
if
have done
I'm allowed
something-
to give my submissions, my lord.
Yes. What do you want to say?
In totality, my lord.
We'll give you 10 minutes.
Yes, my lord.
Yes.
My lord, for easement of the court, my lord, is just a simple list of dates, not just for my lordship.
You're like a phantom, huh? You went there and took them and no one knew.
This is the color they painted, my lord.
Even you don't know.
They
how they
coloring with
cancel.
the-
They don't know who they're cancelling also.
No.
They're both curious case. I mean, they don't know who they are cancelling. You don't know you were cancelled. So
So, my lord, since the first day that my lord has granted me an opportunity to be heard,
was
the first page
this agreement, was it forwarded to the CM Sora?
No, lordship, we have no knowledge of that as well. If that is
I'll
the
give you 10
basis
minutes, yes.
of the argument, then it is on him as well.
No, let him start.
Yes, lordship.
We've heard you.
So, my lord, as you can have the first page, my lord. On the first occasion, I was granted an opportunity of hearing. I've taken your lordships through the first page, which is the introduction and the context of how the petitioner, who the petitioner is, and how did he come to this particular plot of land, and what had transpired after he's received the land. On the last point, which is at serial number 10, is them sending a letter asking us to resubmit the documents, which again, if my lord would have time, I would take you through the documents. The contract itself, there's a precondition, which is we have to submit all the documents before execution of the contract. Now, since we already done that,
What contract?
the agreement, my lord. So before
Yes.
execution of that, submission of the documents was necessary. My lord, is in the repetition.
Yeah, I should speak.
Yes, my lord. The type copy is at page 26. Page 26, yes, my lord. Condition number 8, page 27, condition number 8, my lord. May I read, my lord? That the second party, donee, shall submit all necessary documents that are related to this agreement before the execution of this agreement. This is a precondition, which is an implied condition that must be performed before the execution of the contract. After this, my lord, kindly have the list of dates again. My lord, there are other provisions of the contract I would like to take your lordships through, my lord.
If you come enforcement, you have to go by private dispute.
Nonetheless, my lord. I'm relying on a judgment.
If we are seeking to enforce this
Specific
agreement,
terms,
then
no.
you have to go to private law.
We're not going to
Not by
specific
public
terms, my
law,
lord.
yes.
My lord, I have a judgment on board which I want to take your lordships through,
Yes.
which would consider the document in totality instead of specifics.
Yes.
So, my lord, would kindly have the list of dates again, my lord.
Yes.
On the second page, what had what had followed after the first day of hearing, my lord, there was a query that had fallen from your lordship, which was whether the intestine case is a civil dispute. And I had convinced my lord that the nature of the case itself is civil in nature, but the issues themselves are constitutional in nature. So on the second page, on the second occasion, your lordship granted me an opportunity of hearing. I taken your lordship to the heart of the matter, which is the delay caused by the respondents in issuing the letters. So the second page of the list of dates, my lord, this is what has transpired in the second occasion I've been heard.
Yeah.
My lord, on the second occasion, your lordship had put up a query against the petitioner whether the case itself is maintainable, and due to the glaring fact that there's been a delay of almost 8 years of implementing an order which we were never part to the proceedings, neither were we ever given notice, nor even a copy of the decision when they arrived at. Because of this mere fact, my lord, the petitioner is himself relying on the case of Whirlpool, which was earlier iterated in the previous case, my lord, by the senior counsel, which is the three conditions. Number one is when the petitioner is approaching the court for enforcement of his fundamental right. Number two is when there's a violation or failure of the principles of natural justice, which on the second occasion, my lord, I have shown clearly enough there is a violation, and the fundamental right of the petitioner has also been violated. So the first two conditions through this judgment, Whirlpool Corporation versus Registrar of Trademarks, Mumbai.
One thing, Mr. Come to Annexure 6 of your petition.
Yes, my lord.
What does it say?
Annexure 6, my lord, yes.
6, page 34.
Right, the type copy is on page 35.
The same thing, yes. It's
Yes, my
a
lord.
translation.
Confirmation of the decision of the Darbar, my lord. This,
One thing which this court can't understand,
yes, my lord.
is that the order Paris aim of SORA was on 29th of October 2016. Right. And then this Annexure 6, which you've annexed here,
yes, my lord,
is confirming the decision taken to allot land to you when it's already been cancelled.
My lord, this is the answer which is answerable by a respondent. my lord.
Just that is the thing that they,
Yes, my lord.
they-
We were just given a copy of this.
It
my
doesn't,
lord.
make any sense. And then after that, you had then you applied for electricity connection.
Yes, my lord.
In 17.
Yes, my lord.
This letter 5117. This is next year where they confirm the decision.
Yes, my lord.
Then on 7/12/2018, 2 years after cancellation, you invited the respondent to be chief guest.
My lord, we were not aware of whatever decision they had come to arrive, my lord.
And he came
We
as
were
chief guest.
we were under the
earlier
assumption.
secretary.
Yes, my lord, we
He
were
didn't
there.
tell you it didn't cancel in 2
Not
years
at all,
ago.
my lord. No, as part of my submissions as well in my petition, my lord.
I don't think
we have alleged that we have
been a case like this before this court.
My lord, there's no record on board to show, my lord, there's no record on board which shows that we were given notice at any point in time, nor were we part of the proceeding at any point in time.
We understand that.
as I've
But the
laid
thing
down
is
the
that
facts, my
now
lord.
whoever got whatever he's dead and gone.
Yes, my lord.
But then he is the main culprit.
No doubt about that, my lord. Now the thing is also, there's many more other points I wish to point out to my lordships with the actions of the respondents. I'll stick to the case of the petitioner with regards to maintainability, my lord.
See, it came out in this newspaper, Annexure 10.
Yes, my lord.
Police of Sardar Golden Hour View Resort.
Yes, my lord.
After this was opened, you don't know actions taken CM Sora after that.
We had no idea. We had no idea about what was happening. No, Lordship, because there, see, Lordship, if I may take you to the Annexure 6 of their writ petition, which is 34, the letterhead states.
After this cancel, allow him to appear
Yes, Lordship. We have no idea because it is far away from the HIMA headquarters. So if we look at the letterhead, it says that the Dorbar Elaka Nongsteng, Lordship. Now the Sardar has portrayed himself to be a Sardar of an Elaka, away from the CM-ship of Sora. So, Lordship, if that was the case, that means it's a clear-cut case of. That's a different matter, Lordship. But
between them,
that is not between us and the EU. It is.
I have no functioning whatsoever in the office, my lord. I have nothing at all. I'm just
that
a
makes
private
him
citizen.
a partner, Lordship.
I'm a private citizen, my lord.
If we look at that, it makes him a partner.
Enter to partnership with the new Sardar now.
My lord.
Yes, Lordship.
As far as the conduct is showing thus far, my lord, we are not inclined whatsoever.
He was open to come to this EM, Lordship.
We were, my lord, until and unless they were conducting themselves in such illegal manners.
Okay, anything else to say?
My lord, following these points, my lord, the decision that they have arrived at is not only barred for the delay, but for violating the petitioner's fundamental right under Article 19(1)(g), which is the right to profess any occupation, my lord. And the petitioner's occupation is not barred by law, it's not illegal. The contract itself also is not inherently illegal nor inherently evil. There's nothing of the sort, only for the mere fact that they are standing on the argument that a permission was required. Like the petitioner was required as a precondition to submit all his documents. The permission was a implied precedent condition on their behalf before the execution of the agreement. Now they come here today and say because of that, the contract becomes void. Now contract law itself states very clearly when a contract is void. In situations where a minor enters into a contract, where a person of unsound mind enters into a contract, or whether it's caused by when free consent is not the case in the contract. As far as the petitioner's arguments stand, my lord, all the necessary conditions of a valid contract stand. They only challenge on this point, which is the permission. That is also an implied precedent condition which ought to have been done by them prior to the execution of the agreement. Nonetheless, because of the execution of the agreement, the right of the petitioner came into existence, which is the right under Article 19(1)(g), which is to pursue an occupation which is not barred by law. Now, because of this existence of this decision alone, my lord, the decision itself violates Article 14, 15 and 16 of the Constitution, including the bare fact that it violates the principles of natural justice for the delay. Why 14, 15 and 16 of the Constitution, my lord, is because they term the petitioner as an outsider. Now the petitioner himself is a resident of the very same district they reside in. Granted, he's not a resident having domicile in Sora, but on the basis of domicile, my lord, they cannot discriminate against the petitioner, who is also a member of the Khasi community, holding a valid ST certificate, having served his entire life in the service of the people and the state of Meghalaya. And at the end of his life, my lord, to be called an outsider will be highly violative of his constitutional rights. For these reasons, my lord, the merit and the issue of maintainability are two things tied together. If I'm allowed to take to your lordships through extreme details, I would lead your lordships through all the important aspects of the case, my lord. But however, only for the issue of maintainability, these points that I've shown before your lordship, I've submitted before your lordship, must be taken into consideration before passing any further order, my lord.
Yes. So when did you come to learn about order 29/10/2016? When did you receive it? Was it an extended petition?
My lord, 4/10/2024.
Who gave it to you?
My lord, it was sent by post through the Soda's office, my lord, the respondent number 1.
Okay. Yes, we'll pass orders.
My lord, if I'm allowed to submit my written arguments, my lord.
Yes.
My lord, and there are several judgments regarding the issue of permission, which I relied right on from 1930. Yes. My lord, I'll submit my written argument.
The one thing, you see, the only thing is that what can be answered 29 October, it was cancelled. And the Sardar, he died. When did he die? When did you assume office?
In 2022, my lord, of February. 2022, my lord.
2023, he passed away.
The previous incumbent in 2023 passed away.
See, the thing is that now since 2016, it was cancelled. And then you allowed to start constructing.
Continue.
Inaugurated in 2018, came out in the newspapers.
Yes, lordship.
And Sora was blissfully unaware.
Same of Sora, lordship, had no
Understand,
idea
and he
what was
acted on a complaint of some NGOs.
Yes, lordship. He
without
acted on
even
the
calling the people who allotted the land.
There was no mention of any name whatsoever, lordship.
If your lordship would entertain, my lord, there's certain rules that they were to abide by, and they did not abide by that as well, my lord.
Whether there's been any other allotment?
Allotments, lordship, as per the customary.
My lord, by Sordar, my lord, we have not allotted any. Allotment is given to the domicile of my lord, of Nongsten village, my lord, for residential purposes, my lord.
I humbly interject, my lord.
For commercial purposes, my lord, we have not allotted without the consent of the CM.
Where is Nongsten actually situated?
Nearby Laddo, going forward from Laddo, my lord, going down. And it goes at least all the way to Riwar, my lord. I've personally visited site and even questioned people there also.
You can personally visit site also,
yes,
like detective.
You get the whole picture, so I may assist your lordship, my lord.
There was a ex-judge of this court also who said that when he was a lawyer, he said that if you want to understand, especially title suits, before filing a title suit, you visit the site with the plaintiff, then you get a fair idea of whether he has a case or not.
Yes, if your lordship were to entertain and allow me to present the case in full, my lord, I'll take you through all the details. But until that time, my lord,
yes, it is one which he is away by the villagers.
I've done once, my lord. In Kanapara, my lord, I've done once, and we were chased by the Assamese people.
Can you come with any?
My lord,
please find out. Yes, we'll
Judge,
post it after 1 week, and then we'll run
Yes, may I submit the written arguments?
Yes, you submit.
My lord.
Deeply from
Oh,
deeply
obliged.